Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we'll discuss President Biden's executive order on promoting competition as it relates to consolidation in hospital markets and, relatedly, recent changes made by the Federal Trade Commission to its policies that may have a material impact on mergers and acquisitions in the hospital industry. Hello and welcome. I'm your host, Dan Fahey. I'm an attorney in Epstein Becker and Green's Healthcare and Life Sciences practice based out of our Chicago office. On July 9th, 2021, President Biden issued an executive order on promoting competition in the American economy. The order notes that the administration will enforce antitrust laws to protect competition and address excessive market concentration when and where appropriate. Among other things, the executive order encourages the Justice Department and the FTC to review their jointly issued horizontal and vertical merger guidelines and to consider whether the revisions to those guidelines are necessary. Since that order was issued, the FTC has announced several policy changes, including its abandonment of the vertical merger guidelines and restoring the practice of routinely requiring merging parties subject to an FTC order to obtain prior market approval from the FTC before closing any future transactions that may affect a relevant market. Accordingly, hospital leadership, including boards of directors and C-suite officers, must understand what they are embarking on when considering a transaction in light of this administration and the FTC's policy priorities as it relates to hospital mergers. On today's show, we're going to talk about the FTC and the Justice Department's enforcement policies and priorities relating to mergers and acquisitions in the hospital markets and what stakeholders can expect when embarking on a transaction in light of the President's executive order and recent policy changes. Joining our discussion today is Dr. Subbu Ramanarayanan, Managing Director at NERA Economic Consulting, where he chairs NERA's healthcare antitrust practice. Subbu has extensive experience advising clients on antitrust reviews of proposed mergers and acquisitions before the Federal Trade Commission and the DOJ and state antitrust agencies across a variety of settings in the healthcare context, including a hospital setting. Subbu has testified on behalf of merging hospitals in a number of FTC merger challenges. Welcome, Subbu.
Thank you, Dan. Hello, everyone. It's great to be here today.
Next, Patricia Wagner is a member of the firm in our healthcare and life science practice. She focuses her practice on two of the most complex areas affecting healthcare: privacy regulations and antitrust issues. In the antitrust area, Trish helps hospitals and other integrated nonprofit health systems navigate competition issues and secure antitrust clearance from the Federal Trade Commission, the U.S. Department of Justice, and state antitrust authorities. Welcome, Trish.
Thanks, Dan. It's nice to be here.
Last, John Steren is a member of the firm in our healthcare and life sciences practice. John helps healthcare clients manage antitrust risks and mergers, joint ventures, and other collaborative arrangements, and to defend them against government investigations and enforcement actions. John, along with Trish, co-chairs EBG's Antitrust Service Group and are the authors of the award-winning blog post known as The Antitrust Bite. Welcome, John.
Thank you, Dan. Also nice to be here.
Wonderful. Well, to start, let's discuss President Biden's July 9th executive order on promoting competition. The order itself, it covers many industries. Trish, can you tell us at a high level what is contained in this order and how it may impact hospitals?
Sure, Dan. And I'm going to focus on 4 areas that have the most direct impact on the healthcare industry, in particular hospital transactions. First of all, we have to note that the executive order was intended and really set out the purpose of encouraging the DOJ and the FTC to vigorously enforce the antitrust laws. The agencies, of course, have always vigorously enforced the antitrust laws, but the executive order is a way to send a message that the administration thinks that competition issues are important and they want it to be a focus of their administration. The executive order, and as part of that, as you noted earlier, the executive order and its attached fact sheet encouraged both the DOJ and the FTC to review their current guidelines or then current guidelines to make sure that they were in line with that policy of vigorously enforcing the antitrust laws. There were two other points that have probably a big impact on hospital transactions. One was that the executive order announced a policy that the antitrust enforcement should start focusing on labor markets and the impact of transactions on labor markets. And secondly, the executive order asserted that hospital consolidation had left some rural areas underserved. We're going to talk about all of these. Those are very complex issues. It's very hard to staff a hospital in a rural area. And so when we hear that, we know that the administration is really serious about trying to understand what's happening in hospital markets and how to make sure that there's ready access to care for people in all geographies.
Wonderful. John or Subbu, any other takeaways that either of you had with respect to the order and how it may impact hospitals?
I'll jump in. Just a couple of additional points. Trish went through it pretty thoroughly, but a couple of points. There was sort of a admonition on the federal agencies to engage in more retrospective reviews of transactions that had previously been cleared. And then there was another plug, it seems to me, of the price transparency rules, which many of our clients are struggling to comply with. But I think there's a greater emphasis or greater belief that those price transparency rules will somehow increase competition among hospital clients.
I agree. And the only thing I'll add to, I think particularly to something that John said about retrospectives, is one thing that we hear about and that we are seeing is the FTC is particularly interested in physician transactions. They may fall under the threshold. And so recently there's been an increased interest in understanding, particularly looking back at previous such transactions, what the competitive impact of those transactions were. I think that's been another fallout of this.
Wonderful. Given that this order is fairly broad, it seems like federal agencies have been directed to increase their enforcement efforts and have moved to comply with the directive in part through policy changes. The FTC has been active in the past few months with revised guidelines and new policy changes. John, what are some of the key policy changes the FTC has made recently?
So the FTC in particular has been extremely active in making policy changes that directly impact hospital mergers and their analysis. And it seems to me that sort of the overriding take is they're trying to implement a policy of enforcement by deterrence, so to speak, because a lot of the changes seem to get towards trying to make clients double think their decisions to go forward with a transaction. But specific examples of some of the policy changes that have had significant impacts, there is a clear expansion of the type of markets that the FTC is looking at that are potentially affected by the transaction. Trish mentioned the look at labor markets. They're also talking more about looking at cross-market effects, and they're even looking at the impact that venture capital has on competition when they're looking at transactions. They have made the HSR process both more complicated and more burdensome. There was a fairly extensive blog post from the FTC that talked about some of their policy changes with respect to the Hart-Scott-Rodino process. They have made it more difficult to get the second request modified, which is typically what we try to do immediately once our clients get a second request. Now, before the FTC will even consider modifications, they want to see the identification and description of all the employees that participate in any relevant aspect of the transaction. They also want to understand how data is maintained. They want to know how or what types of discovery tools are going to be used. And they have jettisoned the use of a sort of limited privilege log, now requiring a full privilege log. All this before you can even get a modification to a second request under the Hart-Scott-Rodino process. They have also now started issuing what are referred to as warning letters to parties. This is kind of an interesting advent. They're so backlogged in their review of Hart-Scott filings that they're having trouble keeping up with it. There, of course, is a 30-day statutory waiting period for most of our clients' transactions. The FTC is by statute required to make a decision within that 30 days, although there's some ability to modify that through a couple of avenues. But now they are, instead of sort of going away quietly, they have been issuing warning letters to clients if they're not done with their investigation, saying you are technically allowed to close, but here's a warning that we haven't finished our investigation and we may still come after you. And of course, they could do that anyways, but now they're making it more explicit. They have also abandoned a policy statement dating back to 1995. This was a policy statement relating to prior notice and approval requirements. At that point in time, or at least before 1995, most orders from the agencies required a prior notification and approval process. That was jettisoned. They have now brought that order back, or the requirement back. They have also withdrawn their approval for the vertical merger guidelines. Sort of at face value or at first blush, one might not think that the vertical merger guidelines have a whole lot of impact on the aspect of horizontal mergers between our clients, but within their decision to withdraw it, or at least within their statement to withdraw it, they came out with this explicit statement that they didn't believe efficiencies were a defense. They didn't see it appear in the Clayton Act, and so they really cast some doubt as to the viability of efficiencies defenses, both in a vertical context, and it seems to me in the horizontal context. And it seems to me they have cast some uncertainty in general. This perhaps is not quite a policy change, but at least from the statements, there appears to be now some uncertainty with how the horizontal merger guidelines are going to be applied and whether or not what's in them is still something the FTC will follow as closely as they have in the past. So, Dan, that, as I said, there's quite a bit from the FTC's perspective that has changed since the new administration.
Certainly. It seems like they've obviously been active in a very short timing since the July order. Trish, is there anything that you've noted from the recent FTC policies or blog posts that John has referenced that are worth highlighting?
So I think John provided a nice, what is quickly becoming a laundry list of changes at the FTC. I think, we saw just the other day a discussion from at least two of the commissioners at the FTC trying to get a legislative remedy to extend the 30-day review period. I think that in practical terms, all of the changes that John went through, particularly as it relates to what happens during a second request process, it's really slowing down the ability of parties to respond to the second request in a timely manner. And it just seems like it's creating, as John said, a much more burdensome process for parties who are trying to get a transaction through. And in some cases, timing, or probably for every transaction, timing is critical, right? The more quickly you can close, the more quickly you can start implementing some of the efficiencies or other benefits that will flow from the transaction.
The policy changes that John discussed and somewhat the enforcement by deterrence, as he artfully coined, it seems like hospitals should be adjusting their expectations for how the antitrust concerns will be investigated in the context of a merger. Subbu, what should hospital leaders and boards of directors consider before signing a letter of intent or exploring a possible merger in light of some of the recent guidance we've seen?
So I think hospital leaders would benefit from being prepared and having the right set of expectations with regard to FTC review or DOJ review on a few different dimensions. I think the first has to deal with the substance of the review itself, both in terms of what sorts of deals will get looked at, what sorts of transactions will get reviewed, and then within those, what types of issues are going to be reviewed. So, for example, if you have a transaction that's under the reporting threshold, or if you have a transaction that involves a cross-market merger, meaning it involves combining with a provider that is not within the same market, then there's a question of, is there still a risk of an FTC review or an FTC investigation? And I think based on some of our recent experiences, it does seem like the FTC is broadening its purview and looking at transactions which might involve, cross-market overlaps as well. So on the substance side, I think these executives need to be well prepared and have the right expectations based, of course, on guidance from antitrust counsel. In addition to the substance, so there's also a question of timing, having the right expectations with regard to how long it might take for the transaction to be completed. I think like Trish was just noting and like John noted earlier, we keep hearing about how the agencies are overwhelmed with the number of mergers that they're having to deal with. And what that has translated into, at least in my experience in a couple of recent matters, is that it might take the FTC staff longer to complete their initial review than was the case earlier. So because they have so many items on their plate, it takes time for them to go through all of the issues that they typically go through as part of their initial investigation. And the list of issues has become longer as well. So I think all of that is contributing to some delays in terms of the amount of time it is taking the staff to clear and approve transactions compared to what we were seeing before. And then finally, I think hospital management just needs to be prepared to respond to what are often very granular and detailed information requests from the agencies. Often this is in the form of, data and documents, but sometimes it might also involve time from senior executives who may be called on to have, conversations or discussions with the agencies or make presentations to them to help inform them about, the specific benefits of the transaction. So I think on all of these different dimensions, these policies are having an impact in terms of what executives need to be aware of and need to be prepared for when they are planning these transactions.
Yes, that makes sense. And John, is there anything that you have thought about in light of the recent guidance and somewhat the shift in terms of how the FTC will look at these mergers, about how this may affect hospital clients and what your role, both with respect to the guidance, but what the actual process may change and how the requests that they may receive, anything in that light?
I think Subbu really hit the nail on the head. I think that clients have to understand that the process is going to be longer, that there's more potential for review of transactions that they might have otherwise thought wouldn't garner review, wouldn't raise an eyebrow, and just to hunker down and be prepared that the value of the transaction really has to line up with the pain that the clients may endure to try to get it cleared.
One thing I would add to all of that is there is a focus, as we mentioned earlier in the executive order, to focus on the labor markets. One of the challenges as counselors is that as the FTC starts to look at areas that they didn't traditionally look at, like the labor markets, the FTC is in the process of figuring out what kind of data it needs to review that. At the same time, the parties are trying to figure out what type of data will be helpful. And because it's an area that has not been heavily explored before, it's very hard to have something ready and prepared for that discussion because we don't yet know where the FTC is going with their inquiries. And so it's hard to prepare a response ahead of time.
Great. Thank you, Trish. A lot of our discussion today has been focused on the FTC guidance, but the FTC and the Antitrust Division of the Department of Justice have concurrent jurisdictions to review mergers and acquisitions. I note that the two federal antitrust agencies have not always been on the same page with respect to the antitrust analysis and enforcement policies. Trish, can you give us your views on whether you see the agencies moving forward in lockstep? And if not in lockstep, how any differences might impact hospital clients?
So I think that's a good question, Dan. I think we see it most specifically right now in the fact that the FTC withdrew the vertical merger guidelines while the Department of Justice has not yet done so. Ultimately, that suggests that there are two different policies depending on where your transaction lands, right? Whether it lands at the FTC or the DOJ, what guidelines will apply and what guidance the agencies will be relying on when they evaluate a transaction. Ultimately, I think the benefit we have is that antitrust law is not a regulatory driven law, but more of a case law, right? It is based on case law. And so ultimately, any review will have to meet the requirements of and the standards set out in case law. And I think that may be where things even out a little bit, even if there is a discrepancy between the agencies. Now, if you are a hospital CEO or CFO trying to navigate the process, that may not be a great comfort to you, because the FTC, when they review transactions, if they decide to challenge a transaction, while they go to federal court to get a preliminary injunction to stop the parties from moving forward, the process really is to go through an administrative proceeding. And so all of that can drag out for a long period of time, which, again, when you think about transactions, people do transactions, they want them done quickly. So it's just another factor to be considering as you think about moving forward with a potential transaction.
Certainly. And it seems obviously both the concurrent jurisdiction, but there's also enforcement at the state agencies. And recently we've seen stepped up efforts to test new theories from state agency as well as FTC and emerging theories of harm, including the cross-market effects from proposed mergers. And you somewhat referenced it earlier, Subbu, but cross-market mergers. Can you explain the cross-market theory and what are some of the key economic factors of this theory?
Sure, happy to. There's certainly been more interest in this theory of late. And like you were saying, that earlier this year, we saw the California Attorney General's office include some conditions in their approval of a recent hospital merger in California and the Los Angeles area based on a cross-market theory of harm. So what exactly is a cross-market theory of harm? Let me just step back for a minute. So usually when we're thinking about analyzing hospital mergers, the key question we think about is, what is the extent to which the merging hospitals are seen as substitutes or alternatives by insurers when these insurers are constructing provider networks. And the idea being, if you have a merger that involves providers who are viewed as close substitutes, then the greater the likelihood of harm that could come out of that merger. So that's sort of the underlying economic theory. So now if you have a merger that between two hospitals that are, both located in, say, New York City, which is where I am, then a lot of members belonging to these insurers may view the two hospitals as substitutes because, as patients, they can switch between those two hospitals or choose from between those two hospitals. So by extension, as an insurer, I might view these hospitals as alternatives for forming networks because, again, my members can and do choose between them. So that's an example of a merger that's more, within market. So when you have a cross-market merger, this would be an example where you have, say, a hospital in New York City that's merging with a hospital that's based in, say, Albany, which is 150 miles away. So here, if you think about it from the perspective of patients, then these hospitals are not really viewed as alternatives because very few patients will likely choose between these two hospitals as alternatives. So then the question becomes, is there a scenario under which such a merger, like a cross-market merger, could still lead to harm? And there's some recent economic literature on this topic, which has, does an empirical analysis. They show that, in looking at a number of such cross-market mergers across the country, these papers find some evidence of price increases at the merging hospitals after these cross-market mergers. And the mechanism that they discuss is that if you have common customers across these two markets, like, for example, if you have an employer who has some employees in Albany and some in New York City, and these employers are looking to buy health plans that cover their employees in both these markets, then such a cross-market hospital merger could give the merging hospitals some additional bargaining power because, health plans would need to have those hospitals in network to serve employees for those employers that have, cover both areas. So what this means is basically, the main factors that you look for in thinking through this cross-market theory of harm would be, what is the extent to which you do have such common customers across both markets. So if you don't have too many employers, then across both these markets, then that implies, there's no real mechanism for this theory to apply. So that's one key thing you look for. Another key characteristic you look for is whether the hospitals engage in, all or nothing type contracting, or if, there are examples where some hospitals that are part of the system are in network and some are not. A third key thing you also look for is whether insurers have alternatives in each of these markets. So, can insurers construct networks that exclude these providers in each of these markets. So there are a few different factors like that you look for when you're trying to assess these cross-market theories of harm. I'll just conclude by saying, this is still a fairly nascent economics literature. There are, a couple of empirical papers that have studied this effect. In terms of, the state of play of where the economics literature is, there's still some debate over, what mechanisms underlie the effects that we see in the literature and to what extent those mechanisms apply in any specific context. I think things are still evolving on this front.
That makes sense. And it seems obviously you kind of gave us a nice overview of the economic factors with the cross-market theory. John, do you have any thoughts from the legal side, how the cross-market theory and how the FTC or enforcement agencies may consider it and the harm that it may cause to patients in that area?
It's interesting because there's a lot of discussion at the FTC, in fact, at both federal agencies and elsewhere, about putting together work groups and thinking about new theories of harm that are economic based. And, obviously cross-market theory is heavily rooted in economics, but yet you've got, by the same token, criticism even among commissioners, dissenting commissioners on certain decisions, that some of the FTC conclusions were not quite rooted in economics and not necessarily following sort of traditional economics. Maybe that's a better way to say it, looking at things that are sort of beyond the consumer benefit standard. It's not clear to me ultimately where this will come out. I do think we all know that they are certainly actively considering and thinking about new theories of harm, including cross-market theories. I think it might be a challenge for them to find the right cases to bring that theory. The other sort of related issue that might be a deterrent, the FTC in particular, but both agencies like to run into federal district court and try to get an injunction to stop a transaction before it takes place. And typically what the crutch that they rely on is a concentration analysis using the Herfindahl-Hirschman index and trying to come up with numbers that present a presumption that the transaction is unlawful. And then they run in with those facts and say, Your Honor, let's give us an injunction. I don't know to what extent they might have difficulty doing that with a cross-market theory and some of the other economic theories, and whether or not their inability, if it turns out to be the case, they're not able to do it, but whether or not their inability to do it might deter them from bringing such an action. There is a recent vertical transaction that the FTC withdrew its request for an injunction and just going through the administrative proceeding. It's a bit more difficult for them to do it that way.
Sticking with you, John, somewhat along the litigation context, we spent a lot of time talking about pre-merger considerations. Can you tell us more about some of the consequences of a merger challenge and potential liability and damages that might arise as a consequence for some of these mergers, given the new enforcement priorities that we've seen?
Sure. And maybe to sort of broaden a little bit the scope of the question, because I sort of view it as perhaps not technically a challenge, but whenever the investigation gets beyond the initial 30-day stage and you're into the second request stage, you're technically not a challenge. It's still under investigation. To me, that's all part of the process. That's all designed to raise costs. And part of the process of investigating, the increased use, it seems to me, of second request will both increase cost of going through the process and the overall cost of defending the transaction. If in fact it turns out that the transaction is challenged at court, well, we talked about it before, the FTC has gone back to their positions, the pre-1995 policy statement positions, where they are going to require the transacting parties that have been successfully challenged to adhere to a prior notice and approval process for any future transactions in that relevant market. At least that's the way the pre-1995 policy was. The FTC has actually intimated, perhaps stronger than just intimated, but have indicated that they may go even farther than that for certain transactions if they feel the facts warrant it, and require the parties to undergo a notice and approval process even for transactions that are not in the relevant market. So they're sort of broadening the scope. And they've also now threatened to implement the same notice and approval requirements to parties that actually abandon a transaction before the case goes to court. So the parties are at risk. Before you could try to stave off the FTC as long as you could, thinking that it might get cleared eventually and go through the investigative process. Now I think there's a bit of a heightened risk as to when you might decide to pull the plug and abandon the transaction, that risk being that the FTC may still mandate a notice and approval requirement. Let me also add that this perhaps isn't quite a damage or a remedy, but it does relate somewhat. There's an example of what's going on in New Jersey right now. There appears to be, and parties ought to expect, sort of an open season on attacks to their transactions. Just like what's happening in New Jersey, it's not just the FTC that is coming out and trying to block the transaction, but now they're being faced with amicus briefs from all sorts of third parties, and in fact, state attorney generals trying to take a bite out of the parties for what they've done. So it really sort of expands the potential concerns the parties might face. In general, Dan, to sort of close on it, it raises the stakes in every respect.
Certainly. Trish or Subbu, do you have any thoughts in terms of the kind of the investigation and the costs of that hospitals may face, both currently and probably moving forward in light of this administration's heightened scrutiny of mergers in the hospital context?
The only thing I would add, I think John did a nice overview or summary of all of the parade of horribles that hospitals are facing right now. When I think about it, it goes back to, a comment we made earlier that there really will probably be more of a cost-benefit analysis before any transaction is undertaken to evaluate not just the transaction itself, but whether it is worth withstanding any potential scrutiny. And as I think about that, I think the likely unfortunate victim of that type of scrutiny will be the small rural hospitals where it is almost impossible, if not impossible, to survive as a standalone rural hospital. But they are also small and have limited patients, limited resources. So they will not be usually are not an attractive target for larger systems. And it may be that larger systems, instead of picking them up and bringing them into the fold and trying to make sure that people in rural areas have access to care, it may be that larger systems decide those are transactions that really aren't worth the pain of going through a potential higher scrutiny. And again, although a little convoluted, it seems almost contrary to what the executive order was really trying to achieve.
I agree entirely. And so I want to say I like the turn of phrase parade of horribles. I think it accurately captures what I think many hospitals and health systems are going through as part of this process. I think particularly for the smaller ones, the rural hospital. I mean, we talked earlier about how intrusive this process can be or how burdensome it can be in terms of the types of data that are requested, the amount of information that's requested. And for them, I think in particular, because you have many of these executives who are doing their day-to-day jobs with limited resources to begin with. And then on top of that, they have to figure out a way to respond to these requests in a timely fashion. Putting that all together, I think it does substantially increase the burden that these providers would face if they were to go through something like that, and B, just sort of puts it all into perspective in terms of the cost benefit analysis of here are all the things that we'd have to deal with if you were to go ahead. So then is to weigh that against what they think are the benefits of the transaction. So it certainly does give more food for thought for systems that are looking to engage in such deals.
Certainly. And I think each of you have given us a good overview of both some of the realities and some of the uncertainties that hospitals and health systems are facing recently, both in light of recent years of activity as well as the priorities of this current administration. Before we wrap, I would just like to ask each of you one final question, starting with you, Trish. In connection with President Biden's executive order on promoting competition, the White House noted that the 10 largest healthcare systems now control a quarter of the market. Despite the heightened enforcement that we expect, do you think we will continue to see hospital consolidation?
If I had a crystal ball, I probably would have a better answer for you. I do think we will continue to see hospital consolidation. I think providing healthcare is expensive. I think there are economies of scale that can be achieved when hospitals consolidate. I think that given the drive to have a lot of services be provided on an outpatient basis rather than an inpatient basis. I think that the financial structure of a hospital is very different than it was 10 years ago or even 5 years ago. So I think we will continue to see hospital consolidation. I just think that everyone will have to start thinking about an additional cost to the transaction, just like due diligence, that there may be an additional antitrust review cost to the transaction.
Turning to you, Subbu, what steps can hospitals take in the early stages of a proposed merger to plan for FTC or state agency review and mitigate the risks of delay and challenges to a transaction?
I know this is going to come out as somewhat self-serving, but I do think it is helpful to have antitrust counsel and economists engaged fairly early on in the process. Like we mentioned before, because the agencies are currently so stretched, having to deal with this large volume of transactions, I think it is particularly helpful to go in to an initial meeting with the agencies with well thought out information and analyses that can really help provide some useful context to the agencies for their review and inform them of, the key issues, and also to have data and documents readily available that can help expedite the review on their end. Now, in some cases, the issues are complex enough that you may still end up having a prolonged investigation or a second request. But even in such cases, early engagement, I found, can, help narrow the scope of what the agencies are interested in. It might help pare down the scope of the data and document requests that, the parties will receive from the FTC. So for that reason as well, I think some degree of investment up front in getting the right data, the right information, and undertaking the right analysis is helpful to a large extent.
And finally, John, how do you anticipate your advice to clients may change given the anticipated increased scrutiny that mergers will undergo by the FTC, DOJ, and possibly state agencies?
That question sort of picks up on both what Trish and Subbu were just talking about. First of all, our clients, typically the rationale behind why they decide to enter into a transaction or for very important purposes, whether it be clinical improvements, service improvements, survival mode. It's a point of, we can't allow the antitrust tail, so to speak, to wag the dog. If there are important transactions, the clients still, want to do it and need to do it, and they are improvements in the healthcare system. But nevertheless, directly to the question, what we advise is to start out with a well thought out pro-competitive plan as to the justifications and really thoughtful justifications for the transaction. Get out in front of any potential issues. As Subbu said, good documentation, try to get stakeholder buy-ins that, in addition to sort of feeling out the payers and others that tend to be the primary witnesses that the federal agencies look to. Not a bad idea to try to get some early stakeholder buy-in. And I totally agree with Subbu's initial comment. Might sound a little self-serving, but I think it's right. I think you want to bring in economists very early on in the process so that you can identify potential problems, whether they be large or small, as early as possible so that you can have the best chance of addressing the problem. And I do mean even the little problems. Before, we looked at transactions and started at the big issues, and sometimes that's where the analysis stopped. There's all the more emphasis now to sweat out the small details of the transaction as well if there are potential competitive concerns at any level. I think we also now to be a little more cautious with the use of or reliance upon efficiencies defenses and think of those as important still, but to the extent parties were relying on those exclusively to try to get the transaction through, to perhaps rethink that type of defense. And then finally, be prepared for the slog of a possible antitrust investigation. Don't be scared off by it. Understand that if you're going to go down that road, that the likelihood it might occur has increased, and just be prepared for it.
Great. Well, thank each and every one of you on enlightening our listeners on this complex and certainly uncertain topic, but I'm sure everyone will benefit from each of your knowledge. Thank you.
Thank you.
Thank you.
Thank you again, Subbu, Trish, and John, for joining us on Diagnosing Health Care. I would also like to thank you, the audience, for tuning in. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.